Welcome once again to Lehto's Law. Here's Steve Lehto.
I got a note from my friends over at the Institute for Justice, and this is not good news. The Supreme Court has declined to hear the challenge to the Kelo eminent domain decision. There's a case called Kelo, K-E-L-O, which is a bad ruling. Almost everyone agrees on that. And the Institute for Justice has another case, and they asked the Supreme Court to take the case up and address this issue, and they simply declined to hear it. Now, they could have heard the case and ruled and said, well, we're not going to overturn Kelo, but they declined to hear it at all. So the U.S. Supreme Court declined to hear Bowers Development versus Oneida County, which is a case challenging the 2005 eminent domain decision Kelo versus New London. The property owners contesting the use of eminent domain in Utica, New York, were represented by the Institute for Justice, which also represented the homeowners in Kelo. Kelo, of course, is a case where the Supreme Court ruled 5-4, that the municipality can take property and, in essence, for private use because it somehow betters the community that way. And for years, the government has been able to take property when they're going to do it for a public purpose. So they're going to put a road through and they got to take some property. They compensate you for it. But in Kelo, they took a woman's house, and the theory was they were going to give it to a company that's going to build a factory. And the factory never got built, but they still took her home. The court declined the opportunity to restore some basic protections for American property rights, but it will have to confront this question eventually, said IJ Deputy Litigation Director Robert McNamara. Eminent domain abuse continues to run rampant in New York and some other states that have refused to change their laws, and it will not stop until federal courts return to enforcing the Constitution. Now, remember, I've mentioned this before. In Kelo, they lost the battle, but it looks like they won the war for the most part, because while Kelo continues to enable abuse of eminent domain, its effects have been limited by a nationwide campaign following that decision that led 47 states to amend their constitutions or pass laws preventing eminent domain from being used for private development. We're deeply disappointed that the Supreme Court will not hear our case, said Brian Bowers. New York property owners live with a constant fear that their homes and businesses can be seized and handed over to more politically connected owners. What happened to us can happen to anyone. And remember, if it can happen to anyone, it could happen to you. So you always got to think about that. Utica recently built a new centrally located hospital. Across the street, the CNY Cardiology Group put up a new building for itself and to rent office space. Brian Bowers and his business partner heard that other doctors wanted an alternative to the cardiology building's high rental rates, so they purchased 411 Columbia Street right next door. But the cardiologists were not happy to have competition cutting into their profits. They asked the Oneida County Industrial Development Agency to use eminent domain to seize the property so that they could use it for a parking lot. See, if they put up a parking lot, they'll make money. If it's being used for competition, they'll lose money. So OCEDA, that's the agency, obliged, claiming that the parking lot would create improved job opportunities, even though there are multiple surface parking lots and a parking garage within easy walking distance already. The power of eminent domain is found in the Fifth Amendment of the U.S. Constitution, which requires that property can only be taken for public use and with just compensation. Historically, the power was intended to allow the government to acquire land for essential public projects such as roads, public buildings, and infrastructure. However, in Kelo, the 5-4 majority held that creating jobs or increasing tax revenue was a public use, which is a real big stretch. The dissent countered that this broad definition made the power of eminent domain practically unlimited. Writing for the four justices, O'Connor explained that the government now has license to transfer property from those with fewer resources to those with more. The planned development of the Fort Trumbull neighborhood that led to the Kelo case ultimately fell through, as did other plans over the past 2 decades. The neighborhood where Suzette Kelo's little pink house once stood remains mostly vacant, with a pricey community center under construction, which will pay no taxes, which was the original justification for the taking. And the city offering millions of dollars in tax incentives in the hopes of finally getting someone over there to develop something. So we've heard about this, by the way, where states or entities offer all kinds of tax breaks or loans or cheap money and say, to some entity, build a factory here. And they come in and then they don't quite deliver on their promises. And what are you going to do? In the 20 years since Kelo, everyone from the person on the street to legislators to highly respected judges have said it was wrong the day it was decided, said Scott Bullock, IJ President and General Counsel. He argued Kelo at the Supreme Court. It is high time for the Supreme Court itself to join that chorus, remove this blot on its jurisprudence, and restore constitutional guardrails to the use of eminent domain. IJ will continue to fight eminent domain abuse. Currently, IJ is defending small business owners in Missouri from blight designations that would allow their city to take property and give it to private developers. In Mississippi, IJ is defending homeowners from a blight designation done in secret and that cannot be challenged under state law. And in Georgia, IJ is trying to stop a private railroad from taking homes that have been in some families for generations. And you're a company, you're a business, you're something, and you decide that you want some property, but other people live there. You're going to have to pay them for it. And if they don't want to move, well, not everyone gets everything they want in this world. We've all wanted things we could not have. And what's scary to me is, your home. If your home has been in your family for generations and someone can come by and go, I want that property so I can knock the home down and put a private railroad through. A private railroad. I want to run trolley cars through there. So I have to mention this, as I always do. The Institute for Justice is a nonprofit that exists solely based on the generosity of its supporters through strategic litigation, training, communication, activism, legislative outreach, and research. The Institute for Justice advances a rule of law under which individuals can control their destinies as free and responsible members of society. IJ litigates to secure economic liberty, educational choice, private property rights, freedom of speech, and other vital individual liberties, and to restore constitutional limits on the power of government. So I'm going to put their link in the description below the video, like I do for every video in which I mention them. It's ij.org, ij.org. Go there and look at the stuff they do. And I've had people call me or contact me and say, hey, Steve, I've got a case. I really need good attorneys. Do you think that IJ will help me? And they're not just looking for cases, okay? They're not just looking for fights. They're looking for constitutional law issues. And it's actually, you have to understand this, the most efficient use of their resources. Because if they can resolve a constitutional law issue in a state or at the Supreme Court level, then suddenly they've done something that affects everybody. And I've talked to people before who say, I've got this really interesting case. And they describe it to me and I say, oh, that's an interesting case. It is. It is. And if you go to court and litigate that out to the very, very end and win, that will help you. You. Now, don't get me wrong. You're a very important person. You are. However, the IJ makes good law on a constitutional law issue. It affects everyone. And so it is, like I said, the most efficient use of their resources. They do great work. I've met several of the people who are in this press release. I've talked to Scott Bullock for quite some time on several different occasions, and they do extremely important work. Go to their website, bookmark it, just visit it if nothing else. But you can also sign up for their newsletter, and they have a channel on YouTube. They compete with me. Watch stuff off their channel. But you're going to realize that what they're doing, it's fascinating, but it's important. It's important. And yes, it does affect you. It affects me. It affects all of us. And so, what are the odds that someone's going to come by and go, hey, Steve, we want your property? I don't know about that one specifically, but I can tell you right now, if it happened, oh my, I can't imagine much worse than that could happen to me, short of like a false conviction for something I didn't do. It's right up there, though, in terms of I wouldn't want that to happen to me, And so they're taking on these cases, and they're not doing it just to benefit the one person or the two people. They're doing it to benefit everybody because we all benefit from good case law out of the Supreme Court on constitutional law issues. And we're all harmed by the bad case law. So there you go. The Supreme Court declines to hear the challenge to the infamous Kelo eminent domain decision, but the IJ says they're going to keep fighting on that one. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. It's never too late to have a happy childhood.